And I believe we have a couple more of your bills.
More, AB 1702.
All right, AB 1702, which is file item 9. File item 9.
And
that is, excuse me, that is on consent, if I'm not mistaken. File item 9 was on consent with amendments, so we'll move along.
I apologize.
That's quite all right.
ACR 120.
ACR 120, file item 32, colleagues.
Thank you.
Very good.
ACR 120 is to support an educational data trust pilot project that's the Silicon Valley Regional Data Trust. And it's a cooperation between the University of California, Santa Cruz, counties of Santa Cruz, San Mateo, and Santa Clara. And they're trying to figure out how to better ensure that amongst all of the agencies that deal with at-risk youth, that the information is provided in a timely manner in the way that best supports the youth. Now, the reason that I've brought this forward is I think this is a very significant effort going on at a local level, at this regional level, to really look at how data and information is used for these youth. I want to clarify that this is supporting that data trust only to the extent that they follow all existing state and federal laws. We do not want to encourage them at all to be violating the privacy rights of our kids. But the lack of being able to have the right information at the right time for the benefit of these at-risk youth has been shown to be a real impediment to providing services and making sure that the systems work to the benefit of that individual child that we are talking about. So they've approached me. I had originally tried to do some legislation to support them and really ask the legislative question, or what are the rules we should be looking at? And that's a very complex question. So I think it's incumbent on the legislature to support this and for us to learn from this pilot to understand better what state and federal rules we need to be looking at and to ensure that information gets where it needs to be for the benefit, again, of those children. Obviously, we can't affect federal laws, but they're also looking at federal hurdles to getting information where it needs to be. This will be an instructive pilot program that I think the state can and should be looking at in order to facilitate the conversations around getting information where it needs to be, when it needs to be there for decision makers working across the different disciplines, across the different agencies that deal with at-risk youth to benefit those youth. And I ask for your support.
Thank you very much. Any witnesses here in support? Witnesses in opposition? My understanding is there were no opposition papers filed. So any questions from members? Moved by Senator Morlock. Did you have a question, Senator Monning?
Just briefly, I'm fully supportive of the effort here. I guess my only question, it seems like we're going to a private or nonprofit sector to perform a function that ideally the state would be performing. Any comment on that?
Yes, I have been on a journey on this data and information. In fact, when I chaired Human Services my first 2 years, held a number of hearings to look at impediments to moving data among different agencies and organizations. There are some cultural barriers, there are some legal barriers, there are all kinds of barriers. We were not able to tease out exactly what those were. I'm very interested in this pilot, this data trust, and what they're doing, because I think we can learn from them, which is why I want to make sure part of this is attaching the legislature and state interests to what's going on there so that we can learn, open up channels of communication with them so that we can see what it is we need to be doing at the state level.
So this might actually be a model or inform our eventual adoption that would help state agencies better
Indeed.
Coordinate.
Yes.
Thank you.
Very good. We have a motion. Yes, we do. At this point in time, do you have any desire to close other than ask for an aye vote? Please call the roll.
The motion is due pass to the Senate floor. Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Aye. Anderson, aye. Hertzberg? Leno? Monning? Aye. Monning, aye. Wachowski? Aye. Wachowski, aye.
That bill has 5 votes. We'll leave it on call. Thank you very much for presenting it. And we will now move to file item 6, AB 1580 by Assemblymember Gatto. And I believe you have two bills, and also Assemblymember Irwin is going to be presenting on this as well. Great. All right.
So 1580 deals with, thank you, Madam Chair and Senators. 1580 deals with a well-defined and well-understood problem, which is that identity thieves are targeting children instead of targeting adults in increasing numbers. And that's because children, of course, don't apply for loans as regularly as we adults do. They don't check their credit as regularly as we adults do. And because of that, identity thieves are targeting children at a rate that is substantially higher than targeting adults. The problem, though, is that kids don't have any need for credit usually until they turn 18, but under current law, they cannot freeze, or their parents cannot freeze their credit. And therefore, for sometimes as long as 18 years, these type of fraudulent loans that were taken out in a child's name might go unidentified and unreported. This bill would allow parents to put a freeze on their child's credit file with the three major bureaus, and I respectfully ask for your aye vote.
Much. Assemblymember Irwin.
I think my colleague has covered enough, so I'll just try to cover a couple of extra points. The bill was recently amended to allow county welfare or county probation departments to place security freezes on credit reports of those in the foster care system. And as Mr. Gatto mentioned, it's been well documented that children, especially foster children, are specifically targeted for identity theft because of their clean credit reports. The damages caused by this type of theft can have serious financial consequences for young adults as they grow older. In this era of information sharing and cybercrime, we must develop sensible safeguards to ensure that California's most vulnerable populations are protected from identity theft. We are both grateful for the support of the district attorneys, Common Sense Kids Action, Equality California, and several others, and I respectfully ask for your aye vote.
And as I understand it, you will be accepting the amendments that were proposed on page 7, comment 4. All right, so with that, witnesses in support.
Good afternoon. Danielle Kando Kaiser on behalf of Common Sense Kids Action. First, I want to thank staff in both of the authors' offices for working with us on questions we had on implementation, especially in regards to the foster youth concerns. Common Sense applauds this bill. We are happy that it helps to protect California's children from the risks and harms of identity theft by giving kids and the families the ability to freeze their child's credit, and we look forward to continuing to work with the staff on these concerns with the foster youth advocates.
Thank you very much.
Thank you,
Good
Madam
afternoon.
Chair and members. Good afternoon. Kathy Sunderling with the County Welfare Directors Association. We recently took our support position with the addition of the foster youth language, so we apologize for not getting our letter into the committee. But did just want to note that this piggybacks on a requirement that we already have in law to run credit reports for our foster children when they turn 16, and then to work with them or work with nonprofit organizations to help clean up anything that we find on their credit report. As the author noted, children really shouldn't have a credit report at that time, so if they do, that's an indication that there's a problem. We worked really closely over the years with the Office of Privacy Protection and the Attorney General's office to implement that provision. And my members really like the idea of having this tool to be able to, in those egregious cases, do the freeze on the report. We agree that there's some implementation work to be done here to make sure that we're letting the kids know, letting their attorneys know. Often they go back to their parents, they're reunified ultimately, or they go into an adoptive family, or they end up emancipating themselves as adults. And so ensuring that they understand that they've had a freeze placed and how to lift that freeze is, of course, very important for the implementation of the bill. On balance, we felt that having the tool in place and then working on the implementation as that occurred was a good way to do it, and we took a support position on the legislation as it sits.
Very good. Thank you very much. Other witnesses in support, if you just step forward to the microphone and give us your name and affiliation, please.
Reese Donaldson with AARP on behalf of our 3.1 million members in California. We support this bill.
Thank you very much. Other witnesses in support?
Joe Michael for Equality California in support. Unfortunately, our letter was a bit late for the committee's deadline, but we are in support of the bill. Thank you.
You are not alone in terms of this particular bill. And as I understand it, we have some opposition and a late letter in opposition, so we'll look forward to hearing what your concerns are. We don't generally like late opposition. As a recovering lawyer, it used to irritate the heck out of me when my opposing counsel would suddenly come in after the deadline and get that additional lead because there wasn't enough time to respond. But we'll assume it was done in good faith and that you have some legitimate concern we should consider.
Thank you, Madam Chair and honorable members. My name is Susan Abrams, and I am the Policy Director with Children's Law Center of California. We represent the children in Sacramento, Los Angeles, and Placer County in the foster care systems, nearly 34,000 of California's foster children. We do support this bill conceptually, but we are concerned about the unintended adverse consequences, specifically the provisions relating to youth in foster care. This bill would authorize a county child welfare agency or probation department to place a security freeze on the credit of a minor in foster care. There are no parameters describing when this would take place. There's no mechanism to provide notice to or input from the child or the child's attorney. And most concerning, there's no assistance whatsoever offered to the youth to remove the freeze when necessary. Youth leaving foster care are particularly susceptible to poor outcomes, such as unemployment and homelessness. And in our practice, we have come to realize this is exacerbated by systemic barriers. For example, failure to provide the youth with vital documents. We have many youth who we're trying to get identification for, and that's a huge struggle for us. So concern is that this would become yet another systemic barrier. In the current structure, youth could exit foster care unknowingly with a credit freeze, only to find out when they're denied financial aid or denied a lease or denied a car loan that a freeze was put in place when they were minors. They would have to then figure out from 3 different processes, from 3 different credit agencies, how to remove the freeze. This is not necessarily an intuitive or simple process, especially for a young adult who has limited resources and might not have the documents needed to provide to the credit agencies. Until recently, we understood that several amendments were being considered to address this issue, hence the late opposition. We were disappointed to learn yesterday that those amendments are no longer being considered, and as such, Children's Law Center opposes specifically the language that would authorize a county child welfare agency or probation department to serve as a child's representative absent a court order. I do want to add, removing that language would not leave foster children without protection of their financial security. Legislation was passed, the legislature has passed several laws requiring the agency to look into the credit reports annually once a child turns 14, and that's Welfare and Institutions Code Section 10618.6. Furthermore, children in foster care would still be included in this bill, as it would still apply broadly to children under 16. However, like for other children, a court order would be required to place a security freeze, thereby ensuring notice to and input from foster children and their counsel. We thank you for your consideration of our position.
Thank you very much, and obviously you are good advocates for children. We appreciate the work you do. Again, this was late opposition. I'd like to see, is there any other opposition to the bill? If not, Assembly members, would you be willing to respond to that concern?
Sure. So we very much appreciate the good work that they do. We also appreciate the principles of not being too prescriptive in our legislation here in California. Unfortunately, the amendments that were proposed would have bought us an appropriations problem and a double referral. We're mindful of the fact that Rome wasn't built in a day. We think there's a number of lawmakers who have concern about the number of identity theft incidents, 55,000 a year of minors in California. And we expect that there will be other legislation moving forward, as time goes by. Probably can't solve it all with this one bill. We think this is a very good step forward. It should be noted, though, that this bill does not, we don't want to prescribe how a county has to notify their foster children about these programs. We think that is probably too much to happen out of Sacramento. Nothing in this bill prohibits counties, of course, from saying, we put a freeze on your credit. This is how to remove it when you turn 18, and make that part of the exit from foster care package that foster children get in most counties. Every different county has different needs. Some counties have high percentages of Native American children. Some counties have different percentages of identity theft. And we think it's best to sort of tread lightly from Sacramento in this arena and let the counties determine it for themselves. And we do have faith that the counties who have the good intentions in heart for these foster youth, that they will actually take care of them and provide them some documentation without being mandated from Sacramento.
This is a bit of a dilemma. I hear what you're saying. You know, when these kids turn 18, suddenly they're out of the system and they get piles of paper and, I mean, they're kids, right? And frequently children who have been bounced around all over the place, and suddenly we hand them, oh, by the way, you can do this, you can do that. It's a real challenge. On the other hand, I appreciate that this sort of sets up a framework. I think that there might be things that we can do without so inundating this legislation, you know, weighing it down with so many issues and responses that it sort of dies of its own weight. I'd like to ask if you could come up again representing the county welfare agencies. We've had many discussions about the burdens that already exist on your departments. Valid concerns. I don't think we disagree with that. It's just a question of how much you put on the various agencies at one time. Would you respond and see if there might be some way we can address at least some of those concerns, or maybe we can't. But since the opposition is late, I'd appreciate an opportunity to hear your thoughts on this.
Sure, of course. Kathy Sunderling with the County Welfare Directors Association again. I think, and talking with the bill after the amendments went in with my members, they raised some of the same questions actually that the CLC representative is asking about today. And I think Assemblymember Gatto's point about having the bill collapse under its own weight is a point well taken. So we have talked with them about thinking through ways to do this through implementation, perhaps. It's pretty standard, I think, that when a change of law affects the child welfare system, the California Department of Social Services would work with stakeholders, including us, to figure out an information notice or an all-county letter to send out to the counties to say, hey, there's this new law change. Here's how you should implement that. So that might be one thing to think about, is to, through the implementing administrative actions, ensure that there's an intention. You may or may not have to write that into the bill. I think I'd say I don't think you'd necessarily have to write that into the bill, though certainly bills are prescriptive in that nature, to say, hey, we'd like you to make sure you work with the stakeholders to address these issues related to what do you say to the kids, or if they're reunified, or if they are adopted, what do you say to the adoptive parents, or if they are emancipating on their own. I mean, remember, we have a lot of children who leave to permanency that it doesn't include emancipating as adults. And so there would be a parent of some kind who you could provide this information to. There was this credit history that we found, and so here you go. In the case of these older children that this occurs to, I think it would be more likely that they'd be emancipating on their own more as adults, and so ensuring that in the information that we provide, we've been able to provide that would be one idea. Do you have to write that into the bill? No, you don't have to. You could, but being mindful of the concerns that the author raised. Again, we felt on balance that having this tool enacted here in the Civil Code, you'd have to drag in, I think, the Welfare and Institutions Code if you wanted to put those kinds of requirements on us. And you would, I think he's right in saying that you'd probably end up getting the bill going through extra committees and could create an appropriations problem for the bill. So we were comfortable doing that in implementation work. So.
Okay. Any other questions? I appreciate, I mean, this whole system is just a big dilemma. And I appreciate what you're trying to do. You know, these are young people who are so vulnerable in so many ways, and I just hate to think once they, you know, reach majority, suddenly they can't get credit, or they can't get the scholarships or the aid that they need to go on to school if they're actually so disposed and capable of doing that. Given the response by the Welfare Department, do you see some way we could work, or that you could assist them at some point, if this bill were to pass, to deal with some of the logistics, if you will, the practicalities of this measure?
I think from where we stand and who we represent, we could try to implement that in the counties we represent, but that's only 3 of the counties. I think I agree there is a way to issue state policy that would require notice. It just not guaranteed it would happen. It's not guaranteed it would be created, and then it's not guaranteed it would be implemented. So we would be more comfortable with something in the code. We did suggest adding just a requirement that the county child welfare agency be authorized to request the credit freeze by court order. I think that would at least guarantee notice to the child and notice to the child's attorney. So that was a possible amendment.
If I might, Madam Chair, a gradation on that suggestion would be writing it into the court report, which would also provide, a notification on the national to the parties. The court report is updated at every 6-month hearing. It's a pretty low-key requirement, to be honest. I mean, obviously I don't speak for the Senate Human Services Committee, whether they'd request the bill on that, but adding in that information as a heads up, hey, we found a credit history and we've asked for this freeze, then there is a record of that. And since we have to do the court report anyway every 6 months, this would be, one additional paragraph in an existing court report. It's a pretty low-key requirement, just a suggestion as a possible gradation on that.
Excuse me one second.
Madam Chair, when you get a chance.
Sorry, Senator
I'm listening to this and I'm thinking there's excellent points on both sides. I'm also thinking about that young person who, upon turning 18, realizes their credit is destroyed. And I'm thinking about the process that's required to clean up that credit, and thinking about all my adult friends, and even when my credit was hijacked for a short period of time, and how long it took me, and how protracted, and how diligent, and I wasn't moving around. And I had, I was a really reasonable person, and yet up to 9 months afterwards, and I had to threaten some of the creditors that were pursuing me that it wasn't me that purchased all those products in the East Coast with my credit. A credit card I never requested or knew existed. So then I weigh it against turning 18 and trying to unfreeze your credit, and I'm thinking it's the lesser of two difficulties. And so maybe one of the things we could do is move the bill forward today with the idea that we'll take another crack at it as far as how to unwind it in the most reasonable fashion. But I'm more concerned it's overly difficult to clear up bad credit than it is to get credit. And at 18, there's not many people that can actually qualify for too much credit anyway, so you have a little time there. The other thing that this bill doesn't address, but perhaps the Assembly member would take a look at, is frequently when you do the research, the bad credit doesn't come from non-family members. It comes from family members who have exhausted their credit and destroyed their credit, and now are trying to get credit for from the utilities or for the phone company, and now they're burning through all their kids' credit along the way. All these outcomes are bad outcomes, and I think that this is a small step in the right direction, and I'd be happy to move the bill.
Thank you.
I think the key here is we're talking about most of this, the bad credit comes from fraud and identity theft is the problem. These are ripe young people, and oftentimes they're not with their families. But I'm just wondering, and I'd like to ask the author, if, again, recognizing all the concerns that you have, and I think we all agree that some of the opposition's concerns are, I think, reasonable. Wondering if we might be able, and I don't know if we can do this because I don't like to write legislation during a committee hearing, but this is an area I think we all agree is really critically important, particularly with young people who just have been getting battered around through a system and through life's, importune experiences and all. I think that's a word, importune. But anyway, I'm wondering if we might be able, if you would consider perhaps to avoid the mandate, which would, I think, create a problem in appropriations too, to authorize, as I think was articulated, authorized to request credit freeze information in the court report, which, as I understand, has to be updated every 6 months. So it's not mandatory, it's not requiring it, it's just they're authorized, if they want to request credit freeze information. I think that was what was just suggested. It was kind of parameter type language, no mandate, no insistence, just that it would give the opportunity for that information to be provided during that 6-month update that occurs. Is that something that you would?
I'm talking with our joint author, and I'm not sure we understand what.
Yeah, so it would authorize the inclusion in the social worker's report that is given to the court every 6 months. They'd be authorized to include a status report on a child's credit rating or the freezing of that credit. Is that what you would?
Authorized right now?
And that would be in addition to the language of the bill. Currently, you'd also add in the court report section, it's the case plan section of WIC, an authorization sentence essentially tying back here to say the county is authorized to report to the court regarding a freeze that has been requested from the credit bureaus, period, something like that. Is that what you're suggesting?
That sounds to me like something that could resolve your concerns and also will at least go in some measure towards your concerns about children who otherwise have no idea until they're 18 and they discover that their credit is bad. Could we take that here in committee? Give me 1 second. Again, I'm a little out of my.
We've talked about this, and I want to bring it back to what Senator Anderson said, which is the big picture. The big picture is that there are 55,000 incidents of this per year, and to correct once your credit has been misused takes years, months or years. Now, yes, lifting a freeze when you turn 18, especially if you don't know about it, it could take a week. But to try to amend this on the fly when it risks a double referral and thus killing the bill for the year, we cannot agree on that.
I understand. So what I was going to suggest is if we let this out of committee now, that you will work with the various groups. There's a possibility to get double referred, but with a commitment that you will do your best to work with them so that I understand your concern. I think it makes sense, but I think there's an opportunity here to fix this little problem with little consequence. If the consequence becomes too great, I understand it, but I'd like to ask you to make the commitment to try to do that.
Sure, and what I was going to suggest is that if the bill moves forward and it gets to the floor, that we would take these amendments on the floor so that we don't have to worry about killing the bill during the committee process. So.
And that would be, if you would make that commitment, that will
we'll try our best.
Will assure my vote. All right. Any other questions? Okay. With that, if you'd like to briefly close, we'll entertain a motion. No, you'd like to just ask for an aye vote. Okay. Is there a motion? Oh. All right. Very good. Moved by Senator Hertzberg twice. Or was it Senator Morlock? Had you? A long time ago when we got started here. All right. Very good. At any rate, there is a motion on the floor. And the motion is due pass to the Senate floor as amended currently, and with the understanding that efforts will be made to work out this issue. Please call the roll.
The motion is due pass as amended to the Senate floor. Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Aye. Anderson, aye. Hertzberg? Aye. Hertzberg, aye. Leno? Monning? Aye. Monning, aye. Wachowski?
All right, that bill has 5 votes. Thank you very much. Appreciate all of your involvement, and thank you for this important discussion.
Likewise, thank you.
All right, and we have file item 31, AB 2853.
That's right.
Assemblymember Goddard.